A very good morning to all of you. I very warmly and heartily welcome all the distinguished speakers who are connected to this particular program. Now we are having with us, connected with us, the guest of honor, Honorable Mr. Justice Ravi Malimath, Chief Justice, Madhya Pradesh High Court. Our Patron-in-Chief itself, Professor Dr. Yogesh Singh, the Honorable Vice Chancellor, University of Delhi. And the guest of honor, the guest of honor also, Honorable Mr. Justice Diwaker. From the organizing committee also, we are having Shri Yajwendra Singh ji. And also from MCPC, Supreme Court of India, Sonal Patil. And as a conference director, Dr. Ashutosh Mishra. I also extend a warm welcome to all the judicial officers who have been connected with this particular program. I'm told that there are more than 4,000 these judicial officers who have very enthusiastically have registered themselves to be benefited with this program. And I also extend my welcome to all those moderators and the speakers in various sessions, the 9 technical sessions, and also the other participants who wanted to do this, who do not fall under the judicial officers category. My distinguished colleagues, Professor Rashmi Abhi is also with us. I'm a distinguished member of the Faculty of Law, as well as moderator of one of the session. The students and ladies and gentlemen. Well, as you know that this is the 3rd edition of this International Mediation Conference, which Faculty of Law is going to organize. The first 2 editions of this have been organized under the aegis of Faculty of Law, Law Center 2 taking a lead. And we are still waiting our chief guest to join. Honorable Mr. Justice Injection Call. Can you have any idea, Ashutosh?
I've joined.
Namaskar, sir. Namaskar, sir. Yes, sir. Most welcome, sir. So I was just waiting to, see you. So a very warm and hearty welcome to you for joining and gracing this particular occasion as the chief guest of this occasion. There is
top left second कौन है left में?
Sir is a member of MCPC committee, and in that particular committee has been quite generous enough to support us in this endeavor. Vice Chancellor, sir, I would like to apprise you that Justice Sanjay Kishan Kaur from Supreme Court of India is one of our distinguished alumnus, and he is having a long association with Faculty of Law. Whenever we meet, whether it is a good time of the Faculty of Law or it is a bad time for the Faculty of Law, we always approach the sir, and the sir is kind enough to give us, a lot of time for hours. He listens us and he guides us, how we can really better do the functioning of the Faculty of Law. So, sir, we really hope that your support and guidance will be continued for this smooth functioning of the Faculty of Law. We are really honored to have you as the chief guest for this particular occasion. About the themes and the objectives of the conference, Dr. Ashutosh is going to speak on that. I will not speak on that anything except only one of the things, features of the mediation, with which I am personally very much impressed of. I also happen to teach this particular paper on ADR, which is the compulsory paper in LLB. And that is, that if this mediation is successful, it is able to bring or maintain the, what we can say, peace and harmony between the parties. So this is one of the that unique feature, as I'm saying, I'm personally impressed with, which is, of course, as we all know, which is missing in the adversarial system, wherein we associate the justice with winning of one of the parties parties, and other party. It doesn't happen to be here. And in this particular context, perhaps when we relate mediation with justice, I believe that somewhere or the other, the contours of justice also need to be redefined. Right? Because so long we understand justice as it is based on rights, right-based approach. But when we talk of mediation and relate it with the justice, I think that is surely mediation is not based on rights; it is based on interest. So how when a settlement is arrived at based on interest and not on rights, still we can use the term justice. Because I tell my students, no, I don't use the term justice. I use more the term settlement of dispute. And perhaps, so in that particular sense, I encourage my students that now how the concept of justice is also gradually changing. Well, we are keen to listen our distinguished speakers of this particular session, and therefore I will wind up my session by welcoming you all again and take this honor to invite the Patron-in-Chief, Honorable Vice Chancellor, Professor Yogesh Singh, to deliver his address. But before that, just half a minute I will take, sir, with your permission. Vice Chancellor, sir, just half a minute. It is barely 6 months that Professor Yogesh Singh, sir, has joined the Delhi University, and the pace with which the work is going on and the improvements are taking herein is amazing. Sir, Paul, sir, it's really amazing. And this also happens to be the centenary year, and a lot of committees and subcommittees have been organized under the various initiatives which the sir is taking for centenary celebration. And I would like to bring to the notice of all lordships and all that one of that centenary initiatives relates to the introduction of 5-year law schools. So we are quite hopeful that under the leadership of our Vice Chancellor, sir, this will become the reality very soon. Sir is an institution builder. He has a great experience of heading so many other institutions also, and we are quite hopeful that under sir's leadership, our university ranking, global ranking, is surely going to be increased. Sir, sirf 10 seconds. Okay, sir. Okay, so with these words, I invite our Honorable Vice Chancellor to deliver his address, please. Sir, over to you.
Good morning. Good morning to all of you. Am I audible?
Yes, sir.
Honorable Mr. Justice Sanjay Krishna Kaul, Judge, Supreme Court of India, Member, Mediation and Committee. Honorable Mr. Justice Ravi, Malimath, Chief Justice, Madhya Pradesh High Court, and guest of honor for this third International Conference on Mediation. I would also like to welcome honorable judges of the Supreme Courts and High Courts who graciously agreed to be the part of the conference. Professor Usha Tandon, Dean Faculty of Law, Conference Director Dr. Ashutosh Mishra, Professor Rajni Abi, other participating honorable judges, academicians, students, and my dear colleagues in the university. Good morning again. As we all know, the inception and growth of our university is closely and tied with this saga of rebuilding of modern India. We started as a university in 1922 with only 3 colleges and 750 students. But now we have 90 colleges, 86 teaching departments, 16 faculties, 6.7 lakh students. And now within few days, we will be completing our 100 years in the service of nation. I would like to congratulate all of you. Today, Faculty of Law, University of Delhi, and Delhi School of Public Policy and Governance, Institution of Eminence, University of Delhi, in association with Mediation and Conciliation Project Committee, Supreme Court of India is organizing this third international conference on mediations. The University of Delhi is the center for education and cradle of legal knowledge. It of policymaking and governance in an increasingly complex and challenging world. One of the primary visions of the university is to provide platform for learning and research on public policy and good governance. As we all know, the objective of the conference is to create awareness and capacity building amongst judges, professionals, academicians, research scholars, and students. This is a very, very important task to create awareness and capacity building. Alternative dispute resolution is a tool to achieve goals of speedy, equitable, and adequate justice. Mediation, this conference focuses on mediation, and mediation is an old tradition of India. Many disputes were resolved using mediation, which is a very, very impactful tool. Indian epic Mahabharata is an example of an early attempt of mediation, where Lord Krishna strived to mediate the dispute between Pandavas and Kauravas. This is an example that when mediation fails, what happens? When mediation fails, what cost of mediation is there? So Ramthari Singh Dinkar in Rashmirathi has imagined and expressed the total scenario of that time in a beautiful way. I would like to quote Ramthari Singh Dinkar here from Rashmirathi कि मैत्री की राह बताने को सबको सुमार्ग पर भीषण विध्वस्त पांडव का संदेश लाए, दो न्याय अगर दो आधा दो, पर इसमें भी यदि कोई बाधा हो तो दे दो केवल 5 ग्राम, रखो अपनी धरती तमाम, हम वहीं खुशी के गाएंगे, हम वहीं खुशी से खाएंगे, परिजन पर अस्सी न उठाएंगे, दुर्योधन वह भी ले न सका, आशीष समाज की ले न सका, उल्टे हरि को बांधने चला, जो था असाध्य साधने चला, जब नाश मनुज पर छाता है, पहले विवेक मर जाता है. So here the point is that जब नाश मनुज पर छाता है, पहले विवेक मर जाता है. So when mediation fails, Mahabharata happens. This we have to remember, that's the importance of mediation. And mediation is the most economical and simplest option available to the public for settlement of disputes. Britishers and British government implemented the modern processes in the courts based on British laws courts of that time. And the whole process ignored old traditions and balancing acts. Because in India, when we talk about mediations, then balancing act is equally important, because we have to understand everyone's point of view before taking any decision in order to minimize the conflict of interest. That's why, and the trust deficit, which is very, very important. How do we minimize trust deficit? So to understand everyone's point of view. Someone has rightly said, जिंदगी में ऐसा कुछ करो, जिंदगी में ऐसा कुछ करो कि दोनों का काम चलता रहे, जिंदगी में ऐसा कुछ करो कि दोनों का काम चलता रहे, हवा भी चलती रहे और दिया भी जलता रहे. So Government of India has introduced a draft bill on mediations in 2021. This will provide legal framework and strength to the process of mediation. The conference may provide some insights and thoughts on this bill, and may also create awareness about its salient features. This is the right time for the conference, and that's why I said the topic is very relevant and important. On behalf of University of Delhi, I welcome you all once again, and hope that some good things will emerge from the discussions and deliberations. Thank you all, and thanks to organizers for inviting me in this inaugural session of the conference. Thank you very much, Professor.
Thank you, sir.
Thanks a lot.
Thank you so much, sir. Our joint advocacy and work for prevention and peace must continue with a sense of urgency. Let us all commit to invest in peace, to turn the greatest result of human development into a historic leap forward. Darkness will come into the world, like the darkness of coronavirus, darkness of conflicts, but we should not get nervous by the darkness. Instead, we can say that माना कि अंधेरा घना है, पर दिया जलाना कहाँ मना है? And therefore, we see the lights of suns, our lords, our avatars, our scriptures. There has been enough darkness in the lives of everybody, but they lit up the light, they lit up the lamp. You won't be able to stop the darkness, but you will always be able to light a lamp of hope in your own life and others too. So with this hope, we usually talk about the future of mediation, but now instead of it, we talk about mediation, being the future. On this note, I would like to request Conference Director Dr. Ashutosh Mishra, Assistant Professor, Faculty of Law, University of Delhi, to deliver his introductory speech. Over to you, sir.
Thank you, ma'am. Thank you, sir. Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and member MCPC Mediation Conciliation Project Committee, Supreme Court of India. Honorable Mr. Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh. Honorable Mr. Justice Pritinker Diwaker, Judge, High Court of Allahabad. Honorable Visionary Vice Chancellor, University of Delhi, Professor Yogesh Singh. Respected Professor Usha Tandon, Ma'am, Dean and Head, Faculty of Law, University of Delhi, and other honorable sitting and former judges and esteemed participants. It is with immense pleasure and pride that I welcome you all to the third International Conference on Mediation. In the beginning, it is pertinent to briefly glance back at our previous two editions of the conference. The first International Conference on Mediation was organized by the University of Delhi in association with Mediation Conciliation Project Committee, Supreme Court of India, and Indian Council of Social Science and Research, Government of India, from 6th and 7th April 2019 at Conference Hall, University of Delhi. Under the visionary guidance of Honorable Mr. Justice Nariman and Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, who was also the chief guest of the inaugural session, and Honorable Ms. Justice Indu Malhotra, who graced as our chief guest in the valedictory session. The conference was graced by Honorable Supreme Court judges, High Court judges from different states, and more than 150 judges from all over the country, including over more than 50 High Court judges, world-renowned mediator, expert from international organizations such as United States Patent and Trademark Office, World Mediation Organization, World Trade Organization, Afro-Asian Legal Council, ambassador of other countries were part of it. It gives me immense pride and pleasure to reveal that consequent to the conference, an edited book on mediation was published, which is now a prescribed reading material in many universities across the country. The book was forwarded by the then Chief Justice of India, Honorable Mr. Justice S.A. Bobde, and was released by Honorable Mr. Justice Sanjay Kishan Kaul. Further, in the year 2021, the second International Conference on Mediation was organized by University of Delhi in association with Delhi High Court and Ministry of Law and Justice, Government of India, from 22nd April to 24th April 2021 in the virtual mode. And our chief guest of the inaugural session was Honorable Shri Ravi Shankar Prasad, the then Cabinet Minister of Law and Justice, Government of India, and Honorable Mr. Justice S. Ravindra, Judge Supreme Court of India, was the chief guest in the valedictory session. In its 3-day online conference, it had up to 1,300 participants, including honorable judges, mediator, advocate, academician, and student. The objective of the conference was capacity building and innovative practices. The conference was a success in itself when second wave of COVID was at peak. Immediately after the conference, we had submitted a draft bill on mediation and policy document on mediation as a part of research project under the Action Mediation Program to the Ministry of Law and Justice, Government of India. Honorable Prime Minister Shri Narendra Modi ji said that our aim is not only to improve ease of doing business, but also to improve ease of living for every citizen. In order to put India in top 50 in the World Bank ease of doing business, mediation can play an instrumental role. University of Delhi, which is the most prestigious university of the nation, is making significant contribution and achievement by deliberating upon new ideas and steadily following the path to be in top universities of the world. This time, it is with the idea of promoting mediation under the patronage of Hon'ble Vice Chancellor Professor Yogesh Singh. We are organizing this third International Conference on Mediation, and we are highly indebted to Honorable Chairman MCPC, Honorable Mr. Justice L. Nageshwar Rao, Honorable Mr. Justice Sanjay Kishan Kaul, and Honorable Mr. Justice M.R. Shah, Judge Supreme Court of India and member MCPC. This time we will be having 11 sessions, including the inaugural and the valedictory session. The sessions are namely community mediation and mediation as indigenous form of dispute settlement, online mediation, pre-litigation mediation in the context of ease of doing business, role of mediation in family and matrimonial dispute, commercial and IPR dispute, environmental and infrastructure dispute, cross-border dispute and international mediation and analysis of mediation will. We are delighted to share that conference has attracted more than 5,000 participants, including judges from all over the country. We have representative of the Honorable High Court Honorable High Court judges as a speaker from north to south and east to west, including from north states also. The primary objective of this conference is to create awareness and capacity building amongst all stakeholders to tackle the contemporary challenges in online mediation, community mediation, and other mediation. As an outcome of the conference, we will be coming with our second edited book on mediation, which I firmly believe would be resourceful to other stakeholders. We will also be providing certificate of capacity building and innovative practices to all the participants who would attending all the session and would be filling up the feedback form. I once again welcome all of you, and especially our Honorable Chief Guest, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, Honorable Chief Justice MP High Court, Justice Ravi Malimath, Honorable Justice Pritinker Diwaker, Honorable Vice Chancellor Professor Yogesh Singh, Dean Ma'am, and Member Secretary Yogesh Yajwendra Singh and OST MCPC Sonal Patel. We achieve full confidence through your presence and cherish your blessings and good guidance to promote mediation as a method of resolution of dispute in present contemporary scenario. Thank you, everyone. Thank you.
Thanks a lot, respected sir, for enlightening us and creating hope for mediation being the future. Today, we are fortunate to have our chief guest, Honorable Mr. Justice Pritinker Diwaker, Judge, Allahabad High Court. Mediation is a unique opportunity for the dispute resolution with involvement and participation of parties and their advocates, and mediator acts as a catalyst to bring disputing parties together by defining issues and eliminating obstacles for communication and settlement. And Honorable Lordship is committed towards mediation activities. And during careers, having been dealing with constitution, civil, and criminal matters, and has also been standing counsel of various banks and municipal corporations. So now I would like to request our chief guest, Honorable Mr. Justice Pritinker Diwaker, Judge, Allahabad High Court, to share his profound knowledge with us. Over to you, sir.
Thank you, Madam. Honorable Shri Justice Sanjay Krishna Kaul, Judge Supreme Court of India and Member Mediation Conciliation Project Committee, Supreme Court of India. Honorable Justice Shri Ravi Malimath ji, Chief Justice of Madhya Pradesh High Court. Professor Dr. Yogesh, the Vice Chancellor of the University. Dr. Usha Tandon, Dean and Head Faculty of Law. Mr. Yajwendra Singh, Member Secretary, MCPC. My friend, Dr. Ashutosh, distinguished guests, media persons, ladies and gentlemen. It is my proud privilege to attend this third international conference on mediation, organized by none other than the most renowned and reputed Faculty of Law, University of Delhi and Delhi School of Public Policy and Governance, University of Delhi. Mediation is one of the alternative methods providing justice to the people. Participants attending this conference are well aware about the mediation. It is essentially a negotiation facilitated by a third party, in many cases by the experts also. Unlike arbitration, which is another process of ADR, somewhat similar, mediation does not involve decision-making process by the neutral third party. If we go back to history, in our old tradition, mediation was always available between two persons, between village groups, and between two villages, and the dispute used to be decided by mediation in many cases. The respectable and experienced people of the village used to interfere in the dispute between the two parties. There used to be prominent persons in the villages who were recognized as independent persons, and villagers agreed for resolving their dispute in presence of those persons. Here I would like to remind that these villagers used to be separate from the village panchayat but also used to resolve the dispute between the two. Somehow, after the establishment of the regular courts, our old system was affected in many manners, and the people have started going to courts for redressal of their grievance or for justice. However, now when the court proceedings could not yield immediate result in favor of the parties, therefore the litigants have again started to resort to the old traditional method of mediating and resolving their disputes, which has ultimately given a thought that the ADR system has to be strengthened and the result in the development of arbitration, mediation, and conciliation. I can say that because of heavy burden of work on the courts and increasing litigation, further the tendency of approaching courts even in unwarranted cases had put extra burden on the shoulder of judiciary, which perhaps could not be handled by us as it was supposed to be, compelling us to adopt ADR system. I have no hesitation to say that we are falling back to our old tradition system of resolving the disputes, of course, in a different manner. We can discuss the ADR system plus mediation at length, but in my humble opinion, the discussion must start from the prevailing village condition and the small places of the country. I have reason to say so because in many cases, we discuss about the mediation proceedings on the basis of prevailing system and the difficulties being faced by the public at large who are residing in big towns. The practical problem of the village persons and a person who is residing in small towns is together different from a person who is residing in Mumbai, Delhi, and Calcutta. Whilst settling any such norms or forming rules, we have to consider the ground reality. We are giving training to various mediators of different areas, but with due respect, I can say that we have to focus more at the initial level itself so that dispute can be resolved. The burden of the courts on account of small and petty cases is bothering the nation. To avoid this, we have to strengthen our ADR system, of which mediation is an important link. During COVID-19 and after COVID-19, we have seen the entire new world, and our judicial system has also adopted many new things, result of which could be seen in future. It is needless to point out that during the COVID period, when the courts were functioning on virtual mode, a national Lok Adalat was also conducted by virtual mode, which had produced great result. For the time being, even virtual mediation can be considered, of course, among those who are educated and conversant with the technology. I will again emphasize penetration of mediation in the village and small town. An attempt was made to strengthen our old Panchayat Raj system, but unfortunately, on account of various reasons known to everyone, it could not give the expected result. We have number of good mediators in the big towns, but at the village level, perhaps we have to strengthen our arms. Yet another field which requires more mediation is the family dispute. Because of increasing educational standard amongst the people, including boys and girls, unfortunately, expectations of the husband and wife are increasing such disputes which can be resolved through trained mediators. Here again, we have to have number of experts in the field. In many cases, because of clash of egos, the parties are litigating in courts, and this tendency can be curved out by facilitating the mediation. Virtual mediation may be helpful among the educated people living in metropolitan cities, but it may take some time for the public at large of this country. For judging anything on merit or testing the same on the touchstone, we have to look for the history. If we go to history and mythology, we find Lord Krishna and Angad to be the biggest mediators who had tried to mediate amongst the biggest kingdom. Had their mediation would have successful, history would have been different. Even as on date in number of tribal areas, the dispute is being resolved on the basis of established customary law, as a result of which litigation is not generating from those corners. At last, I would like to conclude by quoting Abraham Lincoln, who once said, "Discourage litigation, pursue your neighbors to compromise whenever you can. Point out to them how the normal winner is often a loser in fees, expenses, cost, and time." Thank you.
Thank you so much, sir, for your influential message. We are charmed by your sharp fluency. Your words shows us the path towards mediation as a future for restoration of harmony with each other and within our community, state, nation, and ultimately in the world. We have heard many times the maxim, justice delayed is justice denied. But the practical application of giving justice within a short time can be experienced by considering the outstanding act of delivering final judgments in 44,886 cases from 2008 to 2020. In a short span of 149 days, the Honorable Lordship has rendered final judgments in 1,401 cases. We are greatly privileged and honored for having Honorable Mr. Justice Ravi Malimath, Chief Justice, Madhya Pradesh High Court, as guest of honor. Honorable Lordship have keen interest in mediation activities. Honorable Lordship was the President of Bangalore Mediation Center and Patron-in-Chief of Madhya Pradesh Arbitration Center, Jabalpur, having experience of Executive Chairman of Karnataka, Uttarakhand, and Himachal Pradesh State Legal Services Authorities. So now, without taking much time, as we all are flattered and eager to listen to the commendable and glorifying words, I request Honorable Lordship, Mr. Justice Ravi Malimath, to deliver his speech. Over to you, sir.
Thank you. Honorable Shri Justice Sanjay Kishan Kaul, Judge Supreme Court of India and member Mediation and Conciliation Project Committee, Supreme Court of India. Honorable Shri Justice Pritinker Diwaker, Judge, High Court of Judicature at Allahabad. My esteemed sister and brother judges who are participating in this conference and the various other judges who are also a part of this conference. Dr. Yogesh Singh, Vice Chancellor, Delhi University. Dr. Usha Tandon, Head and Dean, Faculty of Law, Delhi University. Dr. Ashutosh Mishra, Assistant Professor, Faculty of Law, Delhi University. All the learned participants at the conference, law students, ladies and gentlemen. At the outset, I congratulate the organizers for this conference for bringing to the fore this unassuming but highly effective mode of dispute settlement. Alternatives to the traditional court-based adjudication were first codified through the Code of Civil Procedure Amendment Act 1999 upon the recommendation of the Malimath Committee and the 129th Law Commission report. Resolution of disputes through arbitration and local adalats have been actively sought after over the years. However, there has been some hesitation in adopting mediation and conciliation as primary modes of dispute resolution. Mediation is still looked upon as a precursor to litigation as opposed to an alternative to litigation. The Mediation Bill of 2021 is a major step towards changing this perception. Equally important are conferences such as these, which help in educating and generating novel scholarship on mediation. I would like to primarily speak on two aspects of mediation that are significant in today's context. First, certain observations of the Mediation Bill, and second, the intricacies of online mediation. The salient feature of the bill is that of mandatory pre-litigation mediation. Through Section 6, the bill precludes disputing parties from initiating a civil or commercial litigation unless such dispute has already been subject to mediation. Notwithstanding Section 6, the bill permits parties to approach the court if urgent interim relief is required. An allowance is also made for parties to request for a reference to mediation despite commencement of proceedings in the court. A reading of Section 20, 25C, and 25D of the bill seem to indicate that these sections have the effect of diluting Section 6. The intention behind 6 is to make it obligatory for parties to attempt to resolve disputes through mediation. Section 20 and 25D allow either party to withdraw from mediation post 2 sessions. Section 25C provides for an automatic termination of mediation upon a party being absent for 2 consecutive mediation sessions and failing to communicate regarding such absence to the mediator. In effect, a party would just need to skip 2 sessions to end this mediation. Hence, Section 20, 25C and 25D appear to accord a loophole to those averse to mediation. While it can be argued that mediation must not be forced upon parties unwilling to enter into mediation, and that the imposition of even 2 sessions would prove time-consuming to parties who are eager to settle their disputes, it is pertinent to keep in mind that the settlement of disputes in courts is likely to take more time than that of mediation. There are cases which have been pending since 10, 15, or even 25 years in courts. Unless the relationship between the parties has deteriorated to such an extent that a non-adversarial solution is not possible, pre-litigation mediation is undoubtedly worth attempting. This attempt, however, needs to be undertaken in good faith by both parties. The non-confrontational, confidential, and time-bound nature of mediation would not only be beneficial to the parties at an individual level, but at a macro level. Over time, it would induce people to consider mediation as a serious alternative to litigation. Successful mediation would also help prevent the filing of new cases and ergo, the accumulation of pendencies. Therefore, the language and intent of Section 6, read with that of Section 20, 25C, and 25D, could be further explored. There are few other clarifications that may be required with respect to the bill, such as that of the consequences of not registering a mediation settlement agreement, the absence of flexibility for the parties to extend the mediation beyond the additional 180-day period, and the like. This apart, the bill is forward-looking and envisages unconventional modes of mediation, such as community mediation. Section 19 of the bill rules out the possibility of the mediator acting as an arbitrator in the same case, which is important for the purpose of maintaining the sanctity and confidentiality of the mediation proceedings. This is also relevant in the context of the hybrid med-arb procedure, which is steadily picking up in India. Online mediation is contemplated through Section 32. The pandemic has provided an impetus for courts, arbitrations, and mediations to shift, even if partially, to the realm of video conferencing. The nuances associated with online mediations are quite unique when compared with that of online arbitrations or court proceedings. To this end, the primary challenge likely to be faced by a mediator would be regarding the barrier which is inherent in such an indirect mode of communication. Since the mediation is through a computer or a mobile device, the interpersonal connection that is usually formed during a physical mediation will take time. This interpersonal relationship with the parties is essential because, unlike an arbitration or a court proceeding, a mediator is expected to be empathetic and guide the parties into arriving at a mutually agreeable solution. The mediator would be able to guide the parties successfully only if the parties trust the mediator enough to part with information and facts surrounding the dispute. Creating an environment of trust is difficult in a physical setting, and more so in the online mode. There might be a tendency to distrust the mediator and the counterparty, and consequently display reluctance to furnish information, which would result in an unsuccessful mediation. Another problem which a mediator could face when it comes to virtual mediations is the dearth of modes to determine the non-verbal information communicated by the parties. Since it is not a face-to-face mediation, the mediator would find it tough to glean information which would give an indication as to how the mediation is progressing. In a physical mediation, virtual cues are conveyed through gestures and facial expressions. An observant mediator in a physical mediation would use these to his advantage and direct the proceedings accordingly. These sort of cues might be hard to gauge in a virtual mediation. For instance, lack of eye contact is usually seen as a sign of dishonesty, but this would be onerous to ascertain in a virtual setting. Nevertheless, it is quite possible to overcome these adversities which a mediator encounters in the virtual world. As far as the lack of any interpersonal connection is concerned, steps can be taken to develop some sort of familiarity. For example, the mediators may indulge in a one-on-one telephonic conversation with the parties prior to the mediation to break the ice. The mediators could also share their professional biographies, which could instill confidence in the parties about the possibility of a successful resolution. Through mediations such as these, there can be the creation of a comfortable environment for the parties to ungrudgingly indulge in information exchange. Though this involves an extra effort on the part of the mediators, it's an effectual way to combat these complications. When it comes to the lack of visual cues, the only solution is for the mediator to be watchful and alert so as to detect as much as practicable despite the virtual barrier. Gestures, for example, can still be identified. Hence, though the mediator cannot obtain as much information as is normally feasible, he would still be able to gather at least a certain amount to enable him to steer the mediations. A well-trained and experienced mediator would be able to bridge the gap between a virtual and a physical mediation. Therefore, it can be seen that these are certain issues which a mediator would have to face in the virtual mode, but these are capable of being solved. And at the end of the day, virtual mediations might prove to be more efficacious since there's no additional time and money required as with a face-to-face mediation. In conclusion, mediation is a robust dispute resolution tool which must be employed more enthusiastically. The bill is a welcome move in this direction. Challenges are present in every mode of dispute resolution, but the benefits of attempting mediation greatly outweigh any drawbacks. I once again applaud the organizers for conceptualizing this conference on mediation, and I am thankful for the gracious invitation extended to me. I look forward to hearing the Honorable Chief Guest's address. Thank you.
It was really an extraordinary speech. Thank you so much, sir. We have a long road to travel before mediation reaches a satisfactory level of maturity comparable to some other common law jurisdictions. Each of us individuals possess the seeds of love, compassion, empathy, and forgiveness. These seeds can be developed by practice. If we all start now, then in a couple of generations, we can surely reach to global peace. Moving further, the next distinguished jurist to honor us with his presence is our chief guest, Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India, and member, Mediation and Conciliation Project Committee, Supreme Court of India. Your Lordship has emphasized universal concepts of individuality, liberty, and dignity of individual. Right to privacy, equality of rights, and fundamentals has highlighted the constitutional principles of transformative constitutionalism and constitutional morality. Honorable Lordship has given remarkable judgments and having great contribution in shaping the constitutional spirit and legal system of the nation. My Lord Chief Guest, Honorable Mr. Justice Sanjay Kishan Kaul, is having a proactive role in mediation activities. Honorable Lordship is former chairman of Delhi High Court Mediation and Conciliation Center, also popularly known as Samadhan, which also grew under their guidance. Honorable Lordship is former Patron-in-Chief Mediation and Conciliation Committee, Chandigarh. Since 2019, Honorable Lordship is a member of MCPC Supreme Court of India. Under the guidance of Honorable Lordship, as a member of MCPC, we have conducted various training programs, and around 2,326 judges have been trained as mediators. And during his period, total 10,77,830 cases are referred for mediation in all over the states, out of which 2,20,180 cases are resolved through mediation. Honorable Lordship committed to facilitating and encouraging mediation and to making it success. Honorable Lordship's dedicated and pioneering efforts for the mediation over many years requires no further elaboration. So, I would request Honorable Lordship to add glory in this sensation and to develop the skill of excellency and kindly address the august gathering. Over to you, Honorable Lordship.
Chief Justice Ravi Malimath, Justice Diwaker, the Vice Chancellor, Professor Usha Tandon, all the panelists, my brother judges, the Secretary of the MCPC. The human sapiens are a thinking life form. And any thinking being will have to have a difference of perceptions. It's very inherent in the nature of a thought process. Management of this very difference of perceptions is why a legal system is established. Otherwise, people will be out on the streets settling their scores by using force. This is the fundamental basis, to my mind, of a legal system where an independent person determines who is right, who is wrong, but perceived on basis of societal norms laid down over a period of time. The advantage is it prevents escalations, makes people accept the adjudicatory process and determination of their rights. On the other hand, the negative aspect is that it's a solution thrust on the people. So it's not what you want, but it is what is given to you. The advantage of a mediation is the ability to devise the solutions yourselves between the people who have the conflicts through a mediator who is a neutral person. That is why the mediation training program always begins with that illustrative example of how it is different from an adjudicatory process of taking an orange and where adjudicatory process in case of a 50-50% share would divide the orange. While in case of a mediation, the utility and the problem would be looked into. And thus, if somebody is wanting the juice, another person is needing the rind for a jam, you will do that. That's not possible in an adjudicatory process. I am a votary of mediation not only to ease the processes in courts. That, of course, is one reason, because we have not been able to deal with the quantum of litigation which is pending, but also because it comes up with solutions which is centric to the people who have the disputes and is able to maintain relationships. So whether it's a business disputes, conflict, people can be collaborators, it has been found. If it's a family, you try to bridge the gap. If there's a personal disputes between husband and wife, either you are able to bridge it or make them part as best on terms mutually acceptable to the people. Conflict is inevitable, but combat is optional. And what combat creates is not only something which we derive from our history and mythology of the example of Lord Krishna, but just look around the world today and the morning newspapers every day for the last 1 month, and you will realize what a failed settlement of a failed mediation results in. So we have a live example going on day to day in our scenario, which is quite apparent to us. The step which has been taken, I think, by the Singapore Mediation Convention in trying to build the process of mediation as a resolution method with certain established norms, and India being signatory to it was very significant. The MCPC played a role in moving the aspect further by setting up a committee of trained mediators who interacted with experts across the world to propose to the government a model kind of a law. And of course, the legislative act is for the government to take. But the idea was to bring thought processes prevalent in India and make it available to the legislature in the form of a drafted form rather than only suggestions. It is also to be inconsistent with what is this consequences of being signatory to the Singapore Mediation Center. The creativeness, I feel, and the innovativeness of a mediator is a strength. Often we have found with experience that it is not necessarily a very good litigator is a good mediator. Both things may go together or may not go together, because the skills needed for a mediator are different from the skills needed for a litigator. And whether you imbibe those skills or not is dependent on each individual. I say so because it is very important to emphasize the significance of a training program. We all think we are inbuilt mediators. After all, we resolve disputes within our family, with our children, with our wives in our own home. So each of us is a small mediator in his own ways. But that mediation skills are required to be honed if you are able to deal with the aspects of the current modern mediation. And I believe it is significantly different from the panchayat system, though that's an example given of method of settlement of disputes. Yes, panchayat system was a method of settlement of disputes, but in some way it is also an imposition, because the panch said something, it was followed, not out of a voluntary feeling, but because the panch said so. So it was the informal method of resolution of dispute which was prevalent. While the significance of mediation is to get a solution emerge from the parties. That's why the significance of caucus sessions, of joint sessions. So the mediator is able to put his hand on the pulse what ails the person. And sometimes what ails is very different. It's different from what is perceived in an adjudicatory system. And if you are able to lay your pulse on it because of the informal methodology which is adopted, the result is that you are able to come up with, I would say, a better solution to the problem. Dorothy Thompson had said that peace is not the absence of conflict, but the presence of creative alternatives for responding to conflict. And this is what I am seeking to emphasize while dealing with this issue. Yes, as has been mentioned, that MEDAB is something which is cropped up, but then there are various modifications of our mediation concepts which are there. The most significant part, I think, of the bill, in my mind, is that it introduces the concept of almost a compulsory mediation at the inception. I know there are concerns about it. How will it be tackled? But some concerns will be addressed only when we move forward for it. We must have, of course, mediators at the village level, at the level where the basic disputes are resolved, and imply the significance of mediation where you are prevented from number of tiers of scrutiny. Today, when I sit in the apex court and see the old civil appeal coming up, we are dealing with cases which are as long as a vintage of 40 years from where it started. So these tiers of scrutiny, the adjudicatory process, the delays, the ability of one party or the other to do so, sometimes the lack of professionalism amongst the people who are representing the parties, has resulted in a scenario where we have seen a utilization of the criminal jurisprudence to settle civil disputes because of a perception that the civil disputes take a long time to settle. So in some element of compulsory mediation at the beginning, an incentive to that, I believe, will lend itself to sorting out disputes at the threshold and not let it go on. But what is, I think, cannot be lost sight of, that this would be more applicable to the private dispute system. So far, I have not found the government any government very encouraging to resolve the disputes with the government in a mediation process. possibly a different method of settlement of disputes by the government has to be set in, because nobody wants to take the responsibility of settling a dispute from the government. Maybe an internal panel in government bodies, authorities, to spread the responsibility over a section of people rather than an individual would help in encouraging, because after all, the greatest litigant in our litigation system is the government and the public bodies in one way or the other. The digital form of mediation or online dispute resolution is something of the day. Yes, as was said by Mr. Diwaker and Mr. Malimath, it's not the best form. I also believe that sitting across the table produces that chemistry which helps the mediator in resolving the disputes. But then the online dispute resolution has a special place considering the environment of the last 2 years. It is also significant, especially for the sometimes for the international disputes which are there. Today, in different forms, everybody is looking to a methodology for the earliest resolution. Business can't wait for years. The businessman needs a solution now, a spot mediation, a spot arbitration, to solve the dispute and make the ongoing processes work, rather than take it to another channel and what the business and infrastructure work is going on stops, and we are caught up in our own legal labyrinths of how to resolve the disputes. Commercial relationships and a growing global world is a matter of concern. We want India to be a hub of global activity. Well, if you want to do that, you have to evolve methods of resolution of disputes expeditiously. Whether it's by mediation, whether it's by arbitration, whether it's by court adjudicatory process. In a computer day and age, you can't expect the people to wait for ages and decades to see the end result. Otherwise, the next generation sees it. This is not how I believe the process can go on. To create a business environment in the country, if we want that business to come in, that business needed to be generated for employment and development of the country. So in a holistic sense, mediation has an extremely important role to work out solutions which will be acceptable to the people. We have to create a greater faith, I feel, at times. People have got so used to the litigative system that they somehow feel it's a wastage of time and nothing will work out. Now, even if a small number of disputes get out, they will help in easing the burden on the system and finding good resolutions of the problem. The judges have performed an active role in this as mediators also. I've seen in Delhi district forums and the district courts, the mediation workout where a judge works as a mediator. Of course, he can't be adjudicator and mediator both. But I do believe ultimately mediation must shift to the lawyers, to the supportive role of the judges. With all said and done, a judge wears the cloak of authority, even as a mediator. He trains himself not to wear it, but in the perception of the litigating public, he is a judge. That gives a greater strength, I believe, a greater belief in that person, but it also amounts to not completely a voluntary situation, which would be in the case of a lawyer mediator. It will also dispel the impression amongst the lawyers, some section of the lawyers, I would say, that this is going to take their bread, butter and away. Because mediation over a period of time has evolved in so many countries where it is itself a method of generating your income and employment, and a very satisfactory one at times, where in countries like US, where I've had an opportunity to go and study the system, litigators switched over to mediation and felt that they got a better satisfaction out of the work they were doing. Let us try to resolve the disputes in this world as we see today. I thought that the pandemic of 2 years will make people realize the importance of resolving disputes, but somehow the phase of pandemic is ended with a great world dispute which we are watching. Let us hope we learn from it. As the father of the nation said, there is enough for people's need, but not enough for their greed. And that applies in the individual form, it applies to corporates, it applies to countries. If we want to look to a better world for the future, where we can live in harmony with ourselves and with nature and the other life forms, then we have to resolve disputes, and I think mediation will play a very important role in this. I commend the university for taking up this issue, getting different forums and people here on this forum, and I'm sure the debates which will be generated would be a useful input, considering that the mediation bill is still pending consideration, and the legislature is yet to take a final view on it. Thank you for giving me this opportunity today. I wish you all the best. May I take the liberty of leaving the program, because I had promised to much earlier to join the National Judicial Academy for a program at 12 o'clock. So kindly excuse me.
Yes, sir. Please show why, because Ashutosh has also. Thank you
Yeah.
so much, sir.
Thank you, sir.
Despite your busy schedule, you have taken out time to enlighten us with such a beautiful and wonderful your words. Thank you so much, sir. Thank you.
Thank you so much, Honorable Lordship, for your words of wisdom. It will be great pleasure for us to listen to you again in our future events. Under the guidance of Honorable Lordship, we all are committed to incorporate mediation into court procedures and to continue encouraging litigants to recognize mediation as the primary avenue for resolving disputes. With the joint good efforts of all of us, here I am confident that mediation will soon be regarded by the general public and practitioners in the whole world as the primary and most favored means for resolving disputes. Gratitude is strongly and consistently associated with greater happiness. Respected Mr. Yajwendra Singh, Member Secretary, MCPC, Supreme Court of India, is highly motivated and enriched with lots of energy towards working and making mediation as a remarkable method of alternative dispute resolution. So last but not the least, on behalf of organizing committee, to express gratitude, I would like to call respected sir to kindly address the august gathering. Over to you, sir.
Thank you, OST ma'am. My Lord Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, and also the member of the Mediation and Conciliation Project Committee, Supreme Court of India. My Lord Honorable Mr. Justice Ravi Malimath, Chief Justice, High Court of Madhya Pradesh. My Lord Honorable Mr. Justice Pritinker Diwaker, Judge, Allahabad High Court. Honorable Lordships of the Honorable High Courts of India. Honorable Vice Chancellor, Delhi University, Shri Yogesh Singh, Professor Usha Tandon ma'am. Honorable Judges of the District Judiciary of various states of India, distinguished delegates, distinguished invited guests, ladies and gentlemen. It's indeed my privilege to deliver the vote of thanks for the inaugural session of the Third International Conference on Mediation. With a deep sense of honor, privilege, and humility, I, on behalf of the Mediation and Conciliation Project Committee, Supreme Court of India, express our profound gratitude to Honorable Lordship Mr. Justice Sanjay Kishan Kaul, the chief guest of the inaugural session, for having taken time off your many responsibilities to join us here today. We are thankful to your Lordship for sharing this occasion with us, and indeed for having inaugurated our conference. My Lord has played an active role and has contributed immensely with his valuable inputs in the inception of the proposed mediation bill, and he is a harbinger in the new era of structured mediation. Your Lordship has played a vital role in the growth of the Mediation and Conciliation Project Committee over the period of time. My Lord, your speech has laid due emphasis on the importance of mediation in the alternative dispute resolution mechanism, and it has touched all the crucial aspects germane for a successful mediation. Your Lordship, your speech has laid the foundation, and it will serve as an inspiration for our ensuing deliberations. We are indebted to my Lord. Let me also express my deep gratitude to Honorable Lordship Mr. Justice Ravi Malimath, the Chief Justice of Madhya Pradesh High Court, the Honorable Guest of Honor in this inaugural session, for graciously agreeing to be a part of this conference and for delivering a plenary speech on mediation. I have been fortunate to serve under my Lord and under his dynamic leadership when my Lord was the Chief Justice of Himachal Pradesh High Court. My Lord's presence here today has been of invaluable support to us. We are grateful to your Lordship. My Lord has given a detailed insight on the provisions of the proposed mediation bill. I would like to thank Honorable Mr. Justice Pritinker Diwaker for his invigorating talk on mediation, especially community mediation. We are extremely thankful to your Lordship for joining us. I would also like to thank Honorable Vice Chancellor, University of Delhi, Professor Yogesh Singh, for being part of this conference. We also thank Honorable Dean and Head Faculty of Law, University of Delhi, Professor Usha Tandon, for delivering the welcome address. And of course, I cannot miss the conference director, Shri Ashutosh Mishra, the central force behind all the activities for organizing this conference. We are deeply grateful to all our organizing partners for organizing this conference, namely the Faculty of Law, Delhi University, and Delhi School of Public Policy and Governance. I also thank the office bearers of these institutions for rendering the cooperation to us. On behalf of the Mediation and Conciliation Project Committee, Supreme Court of India, I would like to express deep appreciation for the overwhelming response received from the mediation committees of the Honorable High Courts of India for organizing this conference. I would like to thank all our invited guests for sparing their precious time out of their busy schedule for being part of this virtual assemblage. With the blessings of your Lordships, we have made a thoughtful start with the opening session of Conference on Mediation. On behalf of the MCPC, being a knowledge partner, I thank you all for joining us and look ahead for 2 days of enriching deliberations. Thank you so much. Jai Hind.
Thank you, sir. I know that the respected Member Secretary, Mr. Yajwendra Singh, strongly believes in the need to promote mediation, and there is no doubt that he will provide effective contribution to the MCPC Supreme Court of India. I must also thank the very distinguished speakers in today's conference who have given us much fruitful thoughts and insights regarding the future development of mediation in the whole world. All in all, we should continue with our efforts in the promotion of making good and proper use of mediation and generate peace in the society, nation, and ultimately the global peace. We have planned an interesting conference for you ranging from keynote speeches, insights from the experts, and panel discussions. We hope you all will enjoy the thought-provoking conference. With kind permission of all the honorable dignitaries, I declare that inaugural session is over. Thank you.
Thank you, sir.
The recording has stopped.